soon I'm going to be recorded, so we're just going to get that. I am being recorded? Oh, great. Okay.
Yeah, you have editing ability.
We do. So welcome, everyone. Thank you so much for joining us today. I'm Catherine Wygant Fawcett. I'm the Executive Director of the Institute for Family-Owned Business, otherwise known as IFOB, for the Institute. So I want to thank Key Private Bank for being our title sponsors today, and I'm going to invite Bill up to say a few words.
Well, thanks, Catherine, and thanks everyone for coming out. I'm glad we could reschedule it on a day that was not a blizzard or something. Like I was just saying last night, we were walking out of a restaurant, and I was like, a week ago tonight, it was a disaster. I said, at least it's a little bit better today. So obviously, on behalf of Key Private Bank and Key Bank, thank you for coming, and thank you for organizing this event, and to our speakers for presenting. The Institute has come through many iterations, and the iteration that it's in right now is I think, the healthiest and the best that it's been. And so, Catherine, thank you to you for your leadership and what you're doing in the board and everything. These topics are, I was just talking to Nikki, these topics are really relevant, and not just today, but next week and then in April as well. And we certainly hope that you gain something from it, you learn something from it. At Key Private Bank, obviously, we handle wealth management, and also we deal with a lot of the issues that you're dealing with business succession planning, transfer of businesses from one generation to another. You're living it, you're experiencing it, you are it. And so hopefully the services and the resources that the Institute provides are beneficial to you, and you'll continue to support the Institute and continue to bring in more members as well. So thank you very much, and we're delighted to be the sponsor. Thanks.
Thank you. So now I'd like to welcome our remote users. Do we have any that can pop up on the camera?
Yep, we can see Sage.
Okay, so we have Paula and Sage. Welcome.
Thank you.
Ah, there we go. Thank you. And I'd also like to thank Russell from Hudson University, who's hosting us and is our tech and wonderful expert who helps us here to run these programs. We'll be recording this workshop so others may see it as well. The Institute is a nonprofit that helps family businesses succeed. We have over 40 programs this year. So all members and future members are welcome. So you can check it out on our website at fambusiness.org. And then this is the first in our series, a three-part series. I have postcards over there. We have defensible documentation and HR concepts for managers today. Next week, we have advancements in technology, including cybersecurity, and Nick is going to be leading and moderating that. And then on April 27th, we have supervising the multi-generational workforce. So that'll be fun, and we will have a person from each generation in a family business to represent that. All your employees are welcome. As a member, if you have 400 people, they can all come. It's like Doritos, munch all you want. So have them come and get involved. And you can always remote in. So as you can see, people can remote in. We also, up in the back there, I did have a handout for the programs. So there's a really nice sheet that y'all want to hold on to about how to keep your record keeping and for how long. And we also, speaking of those kind of pieces, the board has instituted a new code of conduct. So each time we have a program or an event, I'm going to address that. So the Institute for Family-Owned Business is a nonprofit organization dedicated to the success of family-owned businesses in the state of Maine. Our purpose is to provide opportunities for family-owned businesses to gain knowledge and expertise concerning the challenges specific to family businesses. Shared expertise comes from IFOB resources, invited experts, sponsors, associate partners, and the family business members themselves. Through the IFOB, relationships will develop that are valuable to all concerned. To foster an environment necessary for trust and sharing, proceedings of the IFOB should not be used for professional advantage. We expect confidentiality in all matters discussed and shared in our programs. Solicitation of business at events or programs is inconsistent with the overall mission of the IFOB. Thank you for respecting this code of conduct. So today we have two very special members. We have Deb Whitworth from HR Studio Group and Tani Alvarez with Veryl and Dina to lead our program. Deb is the owner and CEO of HR Studio Group. She has over 30 years of experience in HR management, so she's really going to be able to help you today. And she serves as the commissioner with the Maine Human Rights Commission. So if you don't do things right, you might see her. So that's why we have. Okay, and then we have Tani, who's our attorney from Veraldina. She centers her practice on the understanding that the employment landscape is ever changing. That's like the world is ever changing, and that you must be proactive. And she is a recipient of the Adolf Hamburger Humanitarian Award. So in just a minute, I'm going to turn it over to them, but in the back too, I also have a survey for the program afterwards. I would really appreciate your input and thoughts on this, because that's how we develop our programs going forward. So thank you very much, and I will hand it over to, who's kicking it off?
We'll let Deborah do hers, and
Deborah
then
kick off.
we're gonna kind of play this back and forth, and we also welcome everyone to jump in during the course of the presentation, because the value of this presentation is really what you guys get out of it. So if we're talking about stuff that you don't find to be helpful to your day-to-day practice, then it's not helpful for you guys. So definitely interrupt us and ask the questions that you have, because that's most important to us.
Absolutely. Don't wait until the end to ask questions. Like, just absolutely jump in. I got to tell you, I'm losing a little bit of control here, not having the clicker. So kick them over there when it's time to go. So the next slide, please. So I think the first thing we need to talk about are documents that you need in your toolbox, and documents that if you were ever to be served with papers, so to speak, from the Maine Human Rights Commission, these are just some of the things that we would want to identify in your personnel files and documents, and we'll talk about documents throughout our presentation. But I think what's important is that we explain to you why you need these documents and why they help you to build your foundation, not only for compliance, but also help you, hopefully everybody here, really wants to develop a culture of excellence in your organization. And without being compliant on all levels, you will never have an organization that is considered one with a culture of excellence. So when we look at the documents that we need, I think Connie and I can go back and forth and talk about the importance of a job description. So I don't think anybody would ever deny the fact that every single job that you have in your organization, whether it's a family member or not a family member, you need to have a job description for that position. And in that job description, you have to include certain basic information. And this creates the foundation for employment in your organization. You will use a job description if you use it correctly. It can be your best friend if it's well written and includes minimum these items. You'll use it for workers' comp, for if you do post-hire physicals, you'll use it there. You'll use it if you have a disability claim. You'll use it for just any variety. You have to have this foundation.
So the thing that most often we hear from clients and friends is that I don't have that kind of time, Tani. I hear it with regards to handbooks, hear it with regards to job descriptions. The great thing is while it's your responsibility to make sure that you have a job description for each of the positions, speak to the people who are currently in that position. Ask them for a week to start keeping track of what it is they're doing. How often are they doing it? What percentage of their day does it take up? At the end of that week, look at the document that they've created and take that and use it as the foundation for creating a job description. In addition to what they're doing on a daily basis, you're also going to need and want to include stuff in there about how much they need to be able to interact with coworkers, how much client client-facing time there is, whether or not they're on their feet. Are they lifting? And when you're giving the assignment to your employees, you're going to mention those type of things. And when you get the task completed back from them, you're going to say, like, so when you were lifting boxes, approximately how large were the boxes? How much did they weigh? How often were you doing it? Were you able to take breaks in between? Could you sit down at your desk and do paperwork and then go back to it? Or is it something that for an hour or 2 hours at a time you needed to be on your feet, moving, lifting, those type of things? So if you don't have the time, or you're a small business where you don't have that front-facing ability, you're going to use that employee's knowledge about what they're doing as the foundation of everything. What I most often see when we get into trouble with clients is that it doesn't include any language with regards to ability to interact with coworkers, right? Sometimes there are jobs in which you can sit in a closet-sized room and not interact with the world except by email. So if your written communication is such that it is not flippant, it isn't derogatory in any sense, fine. If your interpersonal skills aren't great, it's not truly going to affect your ability to do the job well. Other positions, however, are so client-facing that if they are not coming across correctly, if they appear flippant, or if they're not able to work in a team with coworkers, it becomes extremely important and oftentimes is a reason why the individual cannot stay in the position. So when we're having discussions regarding termination or with other job performance issues, if that's not in the job description, oftentimes your employee is going to look at it and be like, what do you mean I'm not getting along with my coworkers? It doesn't say I have to be able to get along with my coworkers. Think from the foundational level that even though it's not listed there, if it is an essential function of the position, have it on that job description. And there's no rule that says a job description can only be 1 page. If it ends up being a 3-page document, it's a 3-page document. But if it is a 3-page document, I'm assuming that not all of the functions on that are essential. So say what's an essential function, what's going to happen other times, what expectations are, kind of group it into different categories in such a way.
And what makes the job description defensible is that you have an employee be involved, as Tani said at the beginning of this, an employee's involvement in writing the job description. They have to take ownership of the job. We don't want to create a job description, hand it to an employee and say, here you go, sign it. Because when there's been no interaction and no involvement with that employee to take ownership and to provide, whether it's the essential functions or whether it's qualifications needed for the job, if an employee is not in agreement and you come to the Human Rights Commission and the employee says, well, I don't do any of that stuff. I maybe do half of that stuff, and they made me sign it when I was hired, and I haven't seen it again for 15 years. Really? The job hasn't changed in 15 years? So hopefully, once you've developed these really great job descriptions with the assistance of your employees, that you take them out once a year and you review them again during the performance evaluation meeting, and you have the employee sign off on it and say, yep, this is still the work that I do. What I like to do with my clients is say, send that job description to your employees via email, so a Word document, and let them redline it. And if they don't have computer skills, if they don't need computer skills for their job, then give them a hard copy of it and a red pen. And let them cross out and mark all over it and say, you know what, I might have done that a couple years ago, but I don't really do that anymore when I think about it. Or, you know what, you really do need a college degree for this job. It's really hard. I don't know how people do it with just let employees be involved. That's how you make the job description defensible. It has to be a document that lives and breathes and that has had involvement, not just from the supervisor writing it. Sure, a supervisor can draft it, but we don't just deliver it to the employee and say, here, sign it. We need to have that involvement in order to make it defensible. You look like you had a question, Lindsay. No?
I'm just loving it.
Okay.
That's great. I'm excited. I thought my dad and uncle were crazy when they told me to write my job description years ago, but I guess they were right.
Yeah. Absolutely. Because who does the job better than who knows the job better than the person doing the work? If you want to know how the work is done, ask the person doing the job. Yeah.
What's your recommendation if, say you have 15 employees who essentially their job function is the same,
Yeah.
but they each write their own description and they're vastly different? How do you hold them accountable for what they're really were hired to do?
First of all, that's a problem. I mean, if you've got 50 people doing the same thing and nobody's on the same page with the job, I think that's a problem. So what you might consider doing is having the supervisor, rather than have an employee write the job description. I think Tawny mentioned having them keep track of what they do throughout the day, throughout the week. I like to give employees a questionnaire and have them complete the questionnaire. And then you can take information from all of those questionnaires to create a draft so that you have consensus among employees that, yeah, one employee may do something 80% of the time, another employee may do it 30% of the time, but basically they're doing the same thing.
Or it might be that you have these 15 employees and they all have the same job title and maybe they should have different ones. That you should be subsectioning these 15 employees and say like, okay, this is shipping and receiving. We have some people who are doing 80% shipping and other people are doing 80% receiving.
Yeah.
Do we take shipping and receiving and create different job categories within one department? So it might be that you're creating new positions based off of this knowledge because the work being done by people who are primarily doing shipping is quite different from the people who are primarily doing receiving. In the same way, it's important that if you are hiring for a position, right, that you already have this document in place. And when you have this document in place, you've taken time to figure out exactly what is required and not required. One of the things the EEOC is focusing more on, right, is pay equity and making sure that we have a diverse workforce. The research in this area of law has shown that men are more likely to apply to jobs in which they are not qualified for, right? Based off of the requirements of the position. Even if a man doesn't meet those requirements, he likely will still apply if he believes as though his other experience could substitute for the required things, right? Women, however, are less likely. If you are going to hire someone who doesn't meet the requirements or qualifications of the position, is it really a requirement of the position? So if you require a master's in business administration, right, and someone comes in and they have a master's of art in fiction writing, but the whole reason you wanted business administration is because they're going to be grant writing a ton, and you thought, oh, that makes sense, but you've got someone who's an amazing writer and who's going to be able to do the grant work, right? Okay, so you needed maybe a master's level education, but it didn't matter what it was in. Or did it really need a master's? Was it really just a requirement of the job was that you had positive prose and that you could get information across in correct methods? So when you're looking at requirements, make sure it truly is a requirement of the position. Otherwise, you potentially have exposure before you've even hired a position. Because remember, we're talking a lot about employees, but defensible documentation also includes applicants. You can be sued as an employer based off of not hiring an individual, based off of a failure to hire claim. So as soon as you put that ad up, you have exposure. So make sure that you've protected yourself from a documentation standpoint from that exposure.
The other thing about, about job descriptions is that very valuable tool during the interview, because you hand an applicant the job description. So far, you've probably only communicated via paper. Like you might have had a phone screening, hopefully you have, before you bring somebody in for an interview. But when you sit down in that face-to-face meeting and you hand that candidate the job description, you're in the driver's seat and you can say, so, you know, the job posting that you applied to, here's a little bit more information about the job. Let me know if you still believe that you're qualified for the position. You then have an employee or a candidate who says, well, you know, yes, I am. You can hold them accountable to that if you hire them. So during the interview, we talked about these three things, and you said that you could do X, Y, and Z, and you gave really good examples of how you could do that. And now you're in the position, and I'm finding that maybe writing skills. And I'm finding that you're not really very good at that at all, but you said that you were. Right? That's what makes documentation defensible. You have a question?
Define when you can hire someone as an independent contractor versus having to hire them as an employee.
Okay, so I also teach an employment law class. I just taught the first class yesterday with another attorney, and this has been a really big, issue. And there's a whole bunch of, there's like checklists that you can go through, primarily, and jump in here, primarily, it has to do with control. So who controls the way the work is done, who controls the job. Like, I'm basically an independent contractor, I'm a consultant, and I do not have a client tell me what to do and how to do it.
So if people give me their business card afterwards, I have a one-page pick your own adventure type document that says, like, if you answer yes to this question, move on to the next question. If you answer no, no deal, not an independent contractor, you have an employee, right? So you're gonna go through 6 different questions. On the 7th question, you're gonna have to pick one out of, 3 out of, you're gonna go through 5 questions. On the 5th question, you have 7 potential, you have to pick 3 of the 7. You have to meet all of those 8 requirements in order to be an independent contractor under Maine state law. And that's the other thing. So this presentation is focused on Maine employers. If you have employees outside of the state, see us afterwards, because there are some differences here. But if you give me a card, I've got this great pick your own adventure page where you can go through it with each of the positions, and you can determine whether or not you have an independent contractor or an employee. And it's very much based off of every single position and what they're going to do, with the control being an underlying aspect of all of it.
The really good thing is that in recent years, the state of Maine has made really good effort in having one definition. So one definition for workers' comp, one definition for tax reasons, one definition for the Maine Human Rights Act, one definition for disability. So one definition of independent contractor, because up until how many years ago? Maybe
2012.
2012?
Yep.
So yeah, 5 or so years ago, you were dealing with all these different definitions, and it's like, okay, who's on first? Because you didn't know. So done a really good job of consolidating and coming to agreement about what is an independent contractor for workers' comp versus all these others. Yeah.
You can also get an application for a predetermination of independent contractor status on the workers' comp board website. So you can have folks complete that application, and they'll get an official ruling from the workers' comp board as to whether there is an employee-employer relationship or not. And they'll be granted a certificate, and that's something that you can keep on file for a year, and it needs to be updated annually, I believe.
And it's one element to the discussion. So even though potentially from the workers' comp standpoint, you could be good, we'd still want you to go through the whole thing. But that is one of the elements that would be looked at by the court as to whether or not you have an independent contractor or employee. And just kind of to follow up with that, if you're talking to people and they're like, no, you just follow the IRS guidelines, they are incorrect on that, right? You have to follow the state law. The IRS guidelines are less stringent than the Maine. So even though it's a completely separate test, if you're an independent contractor under Maine law, 99.9% of the time, you're also going to be an independent contractor under the IRS's different ABC standard. Yeah.
If I could jump back to a point you made a minute ago about the failure to hire regulations. A lot of Maine businesses are hiring interns and part-time people for summer work or what have you. How do those regulations differ in those sorts of situations? Can an intern or a summer, part-time person also sue you for not hiring?
Absolutely. Absolutely. The interns, if you're doing unpaid internships, which I highly recommend clients not do unpaid internship because of the wage and hour nightmare that is created as a result. It potentially is a little bit different because hopefully you have separate agreement and you're working through a school and potentially through Hassan in order to bring on amazing students and soon to be graduates. But so you're looking at wage and hour issues there, but no, seasonal employment, temporary employment, part-time, they all have the same rights in the applicant process. And one of the hard parts about that, and that we see often, is it's always my recommendation that if you have, does anyone have a seasonal business in the room? So for seasonal businesses, I always say that you fire everyone at the end of the season and you rehire them at the beginning of the next season, right? That's when we so often see the failure to hire claims, right? It's because you had someone who thought that they were superstars last year who really weren't superstars, but you didn't do any documentation to tell them that they weren't superstars, right? So they still have in their head that they were superstars. You fail to hire them and they're like, what do you mean you failed to hire me? You didn't hire me because I'm over the age of 40, I'm a Latina woman, I'm like insert protected class as to why you didn't hire them, even though the real reason you didn't is because it wasn't working out last year. But, and we're gonna get into it, if you had proper documentation to show how bad they were the season before, you would be in a better position to explain that failure to hire, and it would be less of a difficult conversation come the new season to say like, we didn't even bring you in to interview because, yeah, no, exactly. But if you don't have the documentation and you haven't had those meetings to let them know what the feedback is, you're in this super awkward position and have exposure based off of a failure to hire claim, even just for the seasonal position. Yeah.
Would it be appropriate in the job description to include expected number of hours worked, or if
Oh,
it
I
was
love putting that in there. Schedule requirements?
yeah,
Oh,
or,
yeah, put some teeth to it.
and I'm even thinking more like for variable hour employees, as it might relate to benefits eligibility, not only for, you know, health insurance benefits and whatnot, but vacation benefits,
Yeah.
et cetera.
You'd also want to put that in your handbook.
Handbook, right,
Yeah.
sure.
But I don't think it's a bad idea to put it. I love having schedule requirements, flexible schedules, particularly if you've got variable hours
Right.
that you're hiring people. Because then think about this, during the interview, somebody says, oh, I didn't have to work weekends. Are you kidding me? And they're thinking that in their head, but they don't say it. You hire them and all of a sudden they're not available for weekends. Well, hey, we talked about this during the interview. I shared the job description with you. I have documentation here, my interview notes that say that you were available for weekends. I mean, I have had this happen. And having that job description with those schedule requirements has been a lifesaver.
Similar to work from home, it's the same type of thing. Like
Sure.
if it is a job that potentially, 8 hours a week, you could do a work from home, but it can't be 100% work from home job, you can have on there possibility to work from home based off of, a year in the position, like if there's requirements in order to meet that, I mean, definitely that should be in your handbook. But if it's a position where there's absolutely no working from home because it's a client-facing position or something like that, have it in there.
Oh, yeah.
No remote working available in this position, and especially with the weekend work. I mean, oftentimes if there's a change in faith in the middle of employment, that you're questioning whether or not it was a true conversion, right? Having in there that weekend work is a required aspect of the job is extremely important so that you don't find yourself in this position where you are questioning the validity of a faith change, which we always recommend that you don't do. If someone says they've changed their faith, they've changed their faith. Let's not get into it, even if it's wearing a colander on your head because you pray to noodle gods, right? I know that sounds silly, but that is a case. That is true. There are religions where people wear colanders, they pray to the noodle god, and they need accommodations for this religion. If that happens, you need to be calling your HR consultant, your attorney, so we can walk you through the appropriate response to what is going on here. And the best way from a documentation standpoint is to have on that job description what the requirements of work are.
And then one more thing about that. So think about a non-exempt employee, you don't have that on the job description, And all of a sudden, the non-exempt employee, they're checking their email on their cell phone. They're like doing a little bit of work here on the weekends. They're doing that. And you put in the job description that they're not allowed to do that. Otherwise, I don't even want to talk about wage and hour claims.
Right.
Because they are huge. They can be potentially huge, big money. So you want to put in those job descriptions for non-exempt employees that they're not to work off the clock, or, you know, the proper language, that these are the schedule requirements, they're not allowed to, you know, whatever, or even put that in your handbook for non-exempt employees that, you know, not able to check email from phones, that kind of thing.
I would even take it a step further and not even give them access to it on their phone, but that is
Well, they can get it.
business
Yeah, I
by
know, right,
business, whether or not they permit that, so.
Have you seen a lot of increase in people using temp agencies and not have to deal with all this stuff?
Oh, it's awesome.
Or PEOs.
We love it.
I mean, really, it's getting, I think it's ridiculous.
Well, with a temp agency though, you're not completely risk-free.
Right.
So, I mean, I think that you still want to evaluate whether or not it's the right fit for you, both from an economic standpoint as well. I mean, I think for seasonal businesses, and I think for, you know, certain kinds of businesses, I think it absolutely, I mean, there's nothing that tells you that you can't do it, but I think you have to, I think you're gonna wanna do in your own head, you're gonna wanna make the business case for it. Have I seen an uptick in that? I have not, personally,
No.
in my business, I have not. Have you?
I recommend against it, and not to, I mean, all the staffing agencies in the area are wonderful and amazing. The reason I recommend against it is because of some very serious and overarching case law that's developed in the last 2 years regarding joint employment liability, in which even though you aren't able to control what these agency employees are doing, you're still liable for it. So if the agency isn't paying overtime at time and a half, right? If the agency is not appropriately taking out taxes, or is not paying for different insurance premiums, or even is creating some kind of hostility that you're completely unaware of because the employee's manager within the sub-entity is not communicating appropriately with your entity, you're on the hook for all that, right? And granted, there's we can get really wordy with documents and contracts as to what the limits of liability are, but the court could care less. The court is going to look at someone to take responsibility for this. And what you end up having is this kind of argument between employer and agency as to who really had control and stuff like that. So I don't recommend it, but if it works for your entity, I just always advise to have somebody look over the contract and attempt to negotiate the terms of the contract in order for you to be provided with as much protection as possible, because I know you're all getting just form contracts that seem as though they're contracts of adhesion, but if the staffing agency wants your business bad enough, they will negotiate those terms.
Okay, this is kind of scary because we're still on.
I know.
Yeah. I'm like, you're good now.
Time is sucking away. No, go ahead.
I was just gonna say, what's worked for us with the temp agency is we've used it more of a trial basis. So within that 90-day period, it's helped us get folks for our plant in the summer. And then if it works out and, you know, we've got all the bugs worked out and they actually show up to work, then maybe we hire them full time or hire them as a gifted employee. It's been a good tool for us to kind of weed through and find people that want to work, you know, back to the basics.
Yeah. Job application. What should you not include? Does anyone have stuff that they know right off the top of their head shouldn't be included?
Age.
Yes, I don't want a date of birth, which also means that I don't want a graphic that says high school you went to, year you graduated from that high school, what you studied. Because as soon as it says year you graduated from high school, the math's really easy. You were between 17 and 20 when you graduated likely, so you can do the math backwards and you know how old they are. Get rid of that. I often recommend getting rid of social security number on it. There is a statute that's being proposed in the legislature which wouldn't allow you to ask it. We'll see how far that goes. There's also legislative language that's being proposed up in Augusta, which is called ban the box, which would make it inappropriate for employers to ask about previous convictions on a job application. They potentially could ask later in the process, but it wouldn't be able to be included on that initial application.
But for now, you can ask it.
Okay. Yeah, we'll keep on.
Convictions, not arrests.
Yeah, never ask for
No,
arrest.
but convictions, and we'll talk about screening in just a minute. But then you wanna have, the EEOC guidance is that you have more information that somebody can write in, because if the conviction wasn't strictly job related, so if someone was convicted of OUI and they're not driving for your company, do you want to exclude them from employment? Probably not. So you need to take that into consideration along with how long ago it actually happened. So people do stupid stuff when they're 16. They wise up and they're not doing that same stupid stuff when they're 30, hopefully.
What about the one I used to get a kick out of was the desired salary? Is that?
Yeah, so
I mean-
desired salary is still all right. I mean, we are having a conversation earlier that if you have Massachusetts employees, you can't ask coming July 2018 what their current salary or any of their past salaries were. That'll be in violation of Massachusetts Equal Pay Act. Maine is looking at instituting a very similar form of legislation, which wouldn't permit you to ask how much people made at previous positions. At this time, it's permissible to ask it. Just keep it in mind that if somebody completely lowballs what you are planning on offering and you offer the same position to someone of a different gender or a different race or anything like that, and you give them double or a third more, just because that person asked for a lot less isn't going to be a defense in any later claim of unequal pay.
Here's the thing, just pay people the right amount of money. Your jobs pay what your jobs pay. And if you've done your homework and you know what the right amount of pay is based on the job, based on somebody's years of experience, based on their qualifications for the job, you've built your range, and you know where this person falls within your range relative to internal equity, okay, and relative to what the market will bear. If you already have that information, it doesn't matter what they're making, it doesn't matter that they're changing careers, doesn't matter what they've made in the past. Just pay people the right amount of money. And if they're not willing to come to work for you for the right amount of money, go to the next person on your list. I do teach comp.
Yes, she
Okay,
You want to jump to reference checking forms?
sure, do y'all do references? Yeah? No? Anybody not do them?
I've never gotten a bad one.
What do you think you can ask? Or no, we'll make this more fun. We'll do like the job application. What should you not ask?
How about this? What should you not answer when someone calls you for a reference? I had a client that once that included on the reference checking form, rate on a scale of 1 to 10 the person's appearance.
Ooh.
Whoa.
Wow.
Is that appropriate?
How do you respond to somebody calling you and saying, would you hire them again? And you wouldn't.
The statute provides that your duty is to be truthful, right? Like if you're providing truthful information, you have quote unquote no liability, right? You only have no liability at the end of the trial that we've defended that has cost you however much in cost of defense and all that kind of stuff. The safest route is to either say, I pursuant to company policy, the information I can provide you with is date of hire, positions held, and date in which the employee left the organization. If you don't feel comfortable giving any more than that, that's my normal recommendation. But I will also,
I do it a little bit differently because I'm in HR, and I think that we have a duty to provide references so that we can get references. And I don't like it when HR people do things off the record, like somebody who you drink with in HR says, hey, can you give me a reference on so-and-so? I'm thinking about hiring. Well, I don't really want to do that because I have higher integrity than that. So I would rather do things completely above board. You can only share factual information. And I tell my clients, first of all, have one person in the organization responsible for giving references. And then you always know that the person who's giving the references has been trained, knows what to say and what not to say, and you don't have some rogue manager who's only giving references to his or her buddies. But you have somebody who's going to pull the personnel file, they're going to pull this authorization form that somebody has signed on their way out the door when they're exiting. So they sign the authorization form and they say, this is the information you can share. So you can tell a future employer about my performance. You can tell them about my pay. You cannot tell them about my attendance. So you can share these bits of information. So this is the authorization form that sits in the exiting employee's personnel file. And they've authorized you to share this information. You're not going to share your opinion. You're not going to share, in my opinion, whether or not you would rehire somebody. What you could share is whether or not they're eligible for rehire. So whether or not you like them or not, if they followed the rules and they left in good standing with your organization, whether or not you hire them again, that is immaterial. What matters is, are they eligible? Did they follow the rules when they left? Did they follow the rules when they were employed here? That's what makes them eligible for rehire. You don't have to hire anybody you don't want to. But are they eligible? And that's what a future employer wants to know. Really, at the end of the day, is this person eligible for rehire? Did they do what they were supposed to do? If you've got this authorization form and you're only sharing factual information that's contained in the personnel file, you're pulling out their performance evaluations that they've signed, so they know that they exist, they've signed, then that's factual information that they know is in the personnel file, not some rogue manager, post-it sticky notes that shouldn't belong in the personnel file anyway. Share with pay, this was the pay when they left, then you're only sharing information that they've authorized you to share and it's factual.
So if you're looking to hire someone and people won't share anything, is it okay to ask for evaluations, like their past evaluations from other employers?
What I would do is create another one of these and have a candidate sign off on it so that whoever you call, a reference checking form, whoever you call for a reference knows that that exiting employee or that candidate has authorized them to share information. Because here's the thing, nobody wants to keep somebody from getting a job, right? The last thing you want is a former employee to be sitting at home thinking about ways that they can sue you. You don't, really? You want to find every reason you can to share factual information. So even though they might not have been the right fit for your company, doesn't mean that they're a horrible person and that they're not the right fit for another company. It just means that they don't work for you anymore. But you do not want to keep them from employment. That's not the goal here. What do you think? So HR and law don't always agree, and I'm used to sparring with the attorney who I teach with, so. And they will typically tell you to take the most risk, but I live in HR. And if I want to get references, I got to give them.
Here's to me the biggest takeaway from this, right? Manager training, right?
Oh, yeah.
I don't want any of my managers other than my HR representative talking to other people about former employees, which means you're sitting down with every manager, you're saying, there's no letter of reference that comes off of your desk because it comes off of my desk. If they're asking for it, great, they can come to me and we can take everything. But I'm not going to have you just randomly providing letters of reference. That's what we see most often. It's an HR manager. It's like, what? So like Jim wasn't supposed to do that. Jim knows better than doing that, right? It's about manager training and making sure everything's directed to one person, that a manager doesn't get a phone call and say, well, it's a personal reference. No, if you are their manager, it's a manager's reference and it's not a personal reference. So making sure that that is there. I'm, again, most risk adverse, right? Section in which to go is data hire, date, relationship ended, positions held during the course of it, and not saying any more. If you have the authorization forms and stuff like that, the problem for me is with an authorization form, if they've authorized you to talk about pay and attendance, but not performance, on the phone call, they're going to be like, well, what was their performance like? And you're going to be like, I'm not authorized to talk about that. And it's going to be like, bam, okay, that's kind of telling me something here. And maybe that works, right? So that, my position on the.
I have a question, this might be silly or stupid or whatever, but.
No stupid question.
So when you sit with your managers and you say, okay, only Cindy Lou Who is able to answer these questions, can you have them sign a form to protect the company that says, I am not authorized to do X, Y, Z? So that if they are at the bar or whatever, and they're sitting with their friend Mo and blah, 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 and one thing they talk about whatever, you can fall back on that?
Yeah, no, after your manager training, you can have a document that you give to everyone that says, like, during the course of this manager training, I now understand X initial. And then when you find out that at Brian Baru's last week, like they just went off on a former employee, you can bring them in and you write them up. And what I see so often is people who are afraid to write up their managers because they're managers, right? If they are not following rules, if they're not managing their team correctly, if there are issues with the team, that needs to be falling on the manager's shoulders, right? Because maybe they're great at doing their job, like the tasks surrounding their job, but they are horrible at managing people. Great. We don't just promote people because they're good at their job. They have to be able to manage people as well. And it might be that we're going to give someone a different title to make them feel special because they are good at their job, but take away the ability to manage people because they just are no good at it. There's nothing wrong with that. And I think people forget that we can call someone a manager, right? The only reason they might have to manage people is for FLSA exemption purposes. Again, a discussion you're going to want to have with a consultant or an attorney, right? But otherwise, some people just can't manage people. And I don't want them doing it because they're just creating more risk for your company.
Yeah. That's why right now what's really popular in a lot of organizations, whether they're big or small, is lateral career ladders, so that somebody who's really good at their job doesn't feel like in order to be to make more money or to be promoted, that they have to actually go into a management or a supervisory position, because it ain't for everybody. And there are certain people who absolutely do not belong in management, supervisory, or leadership positions.
Background screening authorization, third-party screening versus company-sponsored. Third-party screening, you're going to need to follow all Fair Credit Reporting Act rules, laws, mains. Credit Reporting Act is the same as the Federal Credit Reporting Act. When I say Credit Reporting Act, Credit reporting is looked at very broadly as any type of background screening. So it's not just a financial review. It would be your criminal history review. It would be DMV review, all that stuff. If a third party is doing it, it falls under the Fair Credit Reporting Act. If it's a company-sponsored one, right, I want somebody to be responsible for that reference checking, and I always want it to be usually the same person, but there's going to be a time in which it's not the same person, and that's if the chain of command involves somebody who that person would be overseeing, right? So if you're hiring someone in the HR department, right, I don't want the person who's doing the background screening to be in the chain of command, right? Because so often now we're seeing people who are doing background screening on Google. They are just like typing in the applicant's name, approximate location, and Google is just filling in all the blanks. And by Googling someone, you're finding out, in most cases, a host of protected information that you don't want to know. Maybe someone in the organization will find it helpful, but in a lot of cases, the manager shouldn't be aware of that information until after the hire is completed.
I like background screening companies. They provide you with good information and it's really short money. The thing that I talk to my clients about is don't just look at that document that you get, that report that you get, and take it for face value. Like, really look at it. So how long ago was that conviction? So now you know how old the person is, because you can't do it, right, until you get their birth date and their social security number and stuff. So it's after you've made an offer of employment. So you get that information and you think, oh, okay, so yeah, she was 17. Okay, all right, well, you know, she's probably grown up a lot since then. So you look at that and you don't just make these black and white determinations, like we're not gonna ever hire anybody who's had any OUIs. Really? So we can't hire the receptionist because he has an OUI? Like, that doesn't make sense. We don't care how he gets to work. Doesn't matter, it's not a job function. You know, it's not an essential job function to be able to drive. So don't just look at those at face value. Really look at them and have an interaction with somebody in your company who can blow holes through your theory. You say, yeah, you know, I do this every day. Really, are you sure that that's the best decision? Explain to me why. Explain to me why you're not going to make that, you're going to pull the job offer because of X, Y, and Z. So have somebody play devil's advocate with you. You had a question.
I did. So if you choose to do the background screening, do you have to do it consistently for all employees or applicants, or can you categorize them and do it for ones where it would seem more relevant to their duties?
Job description. That's how we do them.
Okay.
Job description,
Okay.
because for some jobs we don't do them.
Right.
But it's consistent in the entire organization. So you don't just pick and choose and just do the background screenings on the people who might be Latino.
And if you have an employee who is refusing to sign the authorization for this, an existing employee, like this is something that you're newly implementing as a procedure, and you want to do all current employees, and you have one that's really pushing back, like how do you?
Well, current employees are a different situation.
Well, if you first you would have to institute you'd have to institute the policy, right? So our new policy is that, and I want you to have a legitimate business reason for the reason why the background screening needs to be done.
Yeah.
The concern is going to be then if the employee's background check comes back with a red flag, right? What are you going to do? That is all, like, are you going to take away the position? You didn't know about it then. What's the difference now? Like, how much greater is the risk? So do you grandfather in your current employees and say, we're instituting this new policy and it's only for new applicants, but that means that if you leave and reapply, you will be subject to this? That is the safest route, right?
Yeah.
A more risky one would be to require everyone. The problem that I have with that is, what are you going to do? So like, if you're looking at 7 years, what within 7 years is going to lead to potential termination? Is it the same as if for your applicants, are you holding the same standard?
Mm-hmm.
That's kind of the issue that potentially can arise based off of it. So unless you feel it extremely necessary to test all your current employees, then I recommend just making it prospective to the institution. But sometimes if I don't like financial institutions, they'll run it fairly regularly just to catch up. But again, you have to have a reason, a very specific reason as to why you're going to do it, and the policy needs to spell it exactly what's going to happen.
So if you do have a background check requirement at your company, you can do it based on the position that the person held. You don't have to do it for every single employee.
You do it based on the job description. So you
Right.
can, if you, for instance, don't want to do dining services because they're all teenagers and they're only here for a year,
Yeah.
then don't do dining services. But if you're going to do nurses, then you do all nurses,
Yeah.
all of them. And if you have a dining services employee who's getting his nursing degree, and then he is applying for a nursing position, then you can justify doing the background because it's a different job.
And in the, usually I say that in the job advertisement say,
Yeah.
and in the offer letter, like that's the other thing, like every
Yes.
offer letter says it's contingent on
Right.
passing the background screening.
Right.
And the next slide.
Deb,
Yes.
before we move on to this next slide, I'd love to hear your perspective on personality assessments. So using that data to make a hire. So there's various ones out there. But
Yeah.
what is your perspective on
Different perspective. So I actually like doing them once somebody's been hired, particularly in a management or supervisory position, because it helps you as an employer to know how to help that person be a good manager or supervisor. I think probably if you use those before hiring somebody, you're looking for ways to screen them out versus screen them in. And if you had good interview practices, then you wouldn't need them. So I think that some organizations do use them as a tool. I think the key here, from my HR perspective, is that you have a lot of tools at your disposal to help you make good hiring decisions. And possibly that kind of assessment could be one of the tools that you use to help you make your decision. I personally would not rely on it 100% because I think I'm a good interviewer and I think I'm gonna hire the right person for the right job at the right time anyway. And if I have to rely on some online personality assessment, then I shouldn't probably be in the job. But I don't think that it's a bad thing to use as a part of that process. I just wouldn't rely on it. I just wouldn't use that as the sole determining factor.
So big data is only as helpful as what the foundational structure of the big data is, right? So what they're finding is that with these assessments, right, the implicit bias of the person who has conducted what the standards are for kind of some of these testing, it's just furthering implicit bias. So if you get your whole organization together, you get 5 or 6 managers who say like, these are the characteristics we're looking for in the employee. This is what we would look at as like a good fit for this position. You're decreasing your chance of furthering implicit bias. But if you have one person in HR who says like, this is what a good fit would be, the implicit bias is just being compounded exponentially by using these algorithms. So I think it's a great tool as long as you are making sure that the implicit bias of every single person is minimized as much as possible.
Because my only concern with them is if you get these back and there's a recommendation to hire and you don't, or you kind of pick and choose based on that recommendation. So could you get in some legal, some potential trouble for, discriminating against certain candidates over others? Or if you just use it as part of your whole, as a tool.
So there's always, to me, 2 handbooks, right? There's your employee handbook and there's your HR handbook, right?
Sure.
And in your HR handbook, you're going to set forth kind of the standards that you're following for hiring decisions, right? And it likely will have a form that involves like all the things we are going to take into consideration when making a hiring decision. Some companies are going to put percentages next to it, and then they make it as a purely a percentage-based value as to if you receive above 85%, the recommendation is to hire and an offer is made. If it's below 85%, right? So you can do it in that way. But I would always factor in-person interviews at a higher level than whatever the big data is saying, and then it minimizes your risk where it says hire. You're like, okay, but you showed up and you know what I mean? Your tie was loose, there was body odor, you weren't able to maintain a conversation. You might be able to pass that personality test, but in person, I can't put you in front of our clients or customers. So just be able to point to the reasons why you're not making the hire.
And maybe somebody else took the personality test. You know, they're online, or so you know. Have Sally do that test. She's wicked sweet. You know? I mean, there's always that. So again, possibly a tool, but then a recommendation to hire is always just a recommendation. So even if you're managers, I mean, who is the one responsible to make that final hiring decision? Somebody's got to, yay or nay. Right? Thank you.
Okay, I think we're gonna have to start flying here. Candidate contact form that has the information on it. Like this is, normally I would recommend you're getting this after an offer is kind of, we're calling it a candidate contact form. I don't know if you have a different position on it, but usually on your application or the resume, you have that basic information. Then you've got the candidate contact form, interview worksheet. Do I really need this? Yes. Short, quick answer. I never tell people they have to do something or they don't have to do something. Mitigate risk as much as possible. You train your managers on how to conduct interviews and you give them a piece of paper, right? And on that piece of paper, before in your training, you've said, you will never write on this piece of paper, woman with red curly hair whose skirt was too tight, right? I know that all of us need like something that's going to help us remember who it is, especially if we're doing a day of interviews where we're just doing one after another after another. You need to figure out another way to remember which candidate it was. And if that person doesn't stick out to you, then they probably weren't the right person for the position, right? So you've already done training about you are not going to say this. And it might be, if you're having a big hiring push, the day before you have a 15-minute with everyone in that room and you're like, we do not ask about their marriages. We do not ask about their children. We do not ask, once they say that there was a gap in their employment and it was based off of care for children, we don't then say, and how do you plan on caring for your children once you get this job? Like, there are definitely going to be things we're gonna wanna tell our managers to stay away from, which very naturally they're going to move towards, because all of our managers are attempting to connect with the applicant on a personal level because they know that they have to work with this person 8, 10, 12 hours a day, 5 days a week. They have to spend more time with this person than the waking hours that they spend with their partner. Right? So they want to really like this person. So they want to get to know them personally. I don't want to know how many marriages there's been, whether or not they're married, how many children there are, how old they are. You can very easily have a getting to know you conversation that is professional.
And let me just say that I have run into this before with clients, that candidates are smart. They're very savvy. And I don't like to be, I know it's Tawny's black cloud.
No, I'm always.
Like the beehive that is HR. Some people will set you up. And they will say, and I had this happen with a client, before I got involved with them, that the candidate said, I just want you to know I have cancer. They felt compelled to hire him. I would not have hired him because I didn't like him. I ended up firing him. Throughout his employment, he pulled his cancer card. Whenever he wasn't on time, whenever he missed, no documentation whatsoever, never asked for it. They do now. They didn't then. And every time he missed work or anything else, oh, I won't be in today, my cancer is bothering me. they walked on eggshells throughout his employment. So I get involved and I start asking for medical documentation, which never materialized. And we were going to deliver a coaching to him. I actually didn't fire him, he fired himself. And he was sitting in front of the manager to receive the coaching, and he said, "F this shit, I quit." And he walked out the door and resigned because he was being held accountable. Be very careful that people may tell you things during the interview to set you up. So you need to train your managers and HR to have they can practice this in the mirror, to have a stock answer and to not write that information down and say, you know, gosh, we won't use that information in our hiring decision. We don't consider that relevant. And then move on to the next question. Do you have a better recommendation?
No, I think that, well, I have an additional recommendation. So after that's said, oftentimes the question will be phrased in such a way in which it is, my child suffers from an illness that oftentimes will require me to be out of work for chunks of time. Is that okay? Right? If the manager responds yes or no, you've just potentially made an accommodation, right? So it's like that information, just like that information won't be taken into account during the course of the process, but I will let HR know and they'll be able to follow up with you if an offer is made. Right? So your managers are never making accommodations based off of health, based off of family circumstances, and you provide them with exactly that answer. Because oftentimes you'll see like, oh yeah, you can work from home a couple days a week, and then they get into the position, their kid gets sick, they're like, I don't need to take FMLA because you said I could work from home a couple days a week. Whoa, no. Because the manager said that, and now you're stuck in this position that you've made this accommodation from the get-go without knowing anything about the applicant and now employee.
So with this interview worksheet, what I like to do, I have about 30 questions or so that I love. They're really good questions. Took me a lot of time to put them together. And I actually print those off in a Word document. There's like this much space between each question. And when I sit with the hiring team or the management team, I'm like, okay, so we've got these 30 questions. We're going to have, build a little rapport. This is how we'll do that. And then let's circle the questions. We're not going to cut and paste. We're not going to do anything. Let's just circle the questions that we're going to use during this interview process so that we stay on script. And there is less likelihood that you'll have a manager go rogue and say, oh yeah, I've got 6 kids too. Isn't that awesome? Now I'll play softball. And then softball becomes an issue, right? Having the kids' games and stuff. So we want managers to stay on script. I don't care if it seems too rigid. I don't care. Because I don't want managers backed into a corner where somebody says, oh, and by the way, I have cancer. And then they feel compelled to hire that individual.
Just a quick question on your medical documentation that you require for absences. Like, where does HIPAA come into play, and like, what can you and can you not require, I guess, without exposing yourself?
So HIPAA doesn't come into play. What comes into play is FMLA and ADA issues, right? You're going to always want to keep this information confidential, which is similar from like a HIPAA. So in a separate file, not in their normal personnel file, right? So you're going to have personnel file and then medical personnel file. And the medical personnel file, you have one for every employee, and all medical documentation will go in that file.
I read folders.
Okay, good.
Yeah. So you have the medical file. If FMLA is applicable as to you as an employer, you're potentially going to have that documentation. You're going to work through that process, either federally or under Maine law. But even if FMLA is not applicable, if you're not a large enough employer, the Americans with Disabilities Act and the Maine Human Rights Act is going to be applicable. Your duty under those statutes is to make a reasonable accommodation, right? Reasonable being like within the terms of who you are as an employer and whether or not you can accommodate. what the employee is seeking. The employee could be seeking something that's just not reasonable. Either it's cost prohibitive, the position doesn't permit it, right? You are allowed, though, to have a dialogue with the doctor or provider, as well as the employee, about what you could do to keep that person at work. The FMLA, though, that's where your hands get tied more, right? There's less that you can ask about if the individual is qualifying for FMLA. So that's where we call it a tangled web between workers' compensation, where the goal is to get an employee back to work, the Americans with Disabilities Act, which again is to get the employee back to work with accommodations if necessary, and then the FMLA, which goal is to keep people out of work. So like all of these three things are working together, and what you can find out from a medical standpoint is quite different from all three.
It's gonna be simple.
Outsource it.
Unfortunately. Interview evaluation form.
I like to have managers have a place to put their notes. So right after, so that you're not writing, you know, the pretty chick with red hair, or, you know, the guy with great legs, or whatever it is. You have an interview evaluation form that gives you an opportunity as a manager to talk about the 10 things with this particular job that you've already discussed that are important to the job. So communication skills, you know, whatever else it is that's important, that person who's doing the interview has an opportunity right after the interview to fill out that form, so that they're not potentially trying to figure out who somebody was 3 days later. But it gives them that opportunity right there to make a decision about whether or not this person could be a potential good fit for the job.
So it's like we were reading each other's minds, right? I never want to see on this piece of paper, not a good fit, right? Not a good fit is like code for some type of implicit bias, right? It's this general phrase that's a catch-all for like, yeah, you're not my type of person, right? My type of person is me. I am amazing. All of our managers think they are amazing. They want to work with people who are just like them because they do their job best, right? So they're going to take their implicit bias about how amazing they are. They're going to look at the applicant and they're going to be like, yeah, you're not like me, right? So you are compounding this implicit bias. If someone writes not a good fit, I want to know why. Most often that means like inability to socially interact, awkward pauses, right? That's what normally this means, like not a good fit, but you are going to need to push back as to what they mean by not a good fit. You're going to have them cross it out. You're going to have them write exactly why they're not a good fit, whether or not it was a personality conflict or it was something with regards to what you perceive their work to be like, or during the course of the conversation, they mentioned that they couldn't get along with their previous employer, right? So you're thinking not a good fit, like hands off, not a good fit. What you really mean is serious concerns about inability to be managed by previous. Put down exactly what it is. And one of the things that I often like, in addition to the interview evaluation form, is to get everyone together in a room. Because you might have someone who's saying not a good fit and they just can't verbalize it. Maybe that's not their strength, is to find the words that fit with the social interactions. And when they're sitting around at a table and someone goes, I noticed that they were unable to answer my questions in a thorough, thoughtful way, and they answered questions that I wasn't asking and just talked and talked and talked, right? Someone else is going to say, oh, I noticed that too, and I didn't realize it. That's what I meant by not a good fit. It's just that their mind can't verbalize why they weren't a good fit, because you have to remember all of us process information in very different ways. When you bring the group together, it could assist in the processing. Granted, it could screw up some of the processing, but knowing your managers is the best way then to minimize risk in that regard.
No interest letter or offer letter. I hope that everybody is using these. A lot of people bypass doing a no interest letter, but here's the thing. We all live in Maine. Maine has the population of Cleveland, so there's not a lot of us to go around. You're still a community member. How far does goodwill go when Giffords sends out a letter and says, thank you for considering us for employment, very brief. We've decided to pursue other candidates. Good luck in your employment endeavors. Okay, that person says, well, I didn't get the job and I really wish that I had had it. But wasn't that great that they let me know rather than leave me hanging on for 6 weeks?
Absolutely.
So, yeah.
Now, what about in between the point of the interview or the application and the decision-making? What's the proper obligation of the employer in communicating with the candidates?
So letting a candidate know that they won't be invited in for an interview? Is that what you mean?
Or that, for instance, I had a situation where they posted a position and it went on for months. And they were still figuring out whether they wanted to fill a position or rewrite the position. And they had a pool of people that had applied. Do you go back to them and say, we're pausing our decision because or do we say nothing?
I've actually been in that situation with clients, and I do let people know. That's me, because I think really good jobs with good employers are not that easy to find. And from an employer's perspective, really good candidates who have the skills that I want are not really easy to find. So I think courtesy from the HR department goes a long way. And even if somebody doesn't get that job at Giffords, he's still gonna say, you know what, I didn't get that job, but I got this letter, so yeah, why don't you go apply there? I mean, that goodwill goes so far in not leaving people hanging. And if you're a big volume employer and you're just hiring a ton of people, my gosh, have some postcards printed up and just send out the postcard if you made a decision not to pursue a candidate further. I mean, just let them know that courtesy goes so far. You look like you still have a question, so I didn't
Well,
answer
I'm just, in terms of thinking from the employer standpoint, particularly the smaller companies, managing that process. I'm just thinking of ways, you send out a letter, do you post it on a
Well, if they
on the
apply
website?
on your website, you can have an automatic response to them saying, thank you very much for your application, we received it, blah, blah,
I'm
blah.
talking about, we paused the hire because now we've seen the pool of candidates, we're looking at filling the position, but maybe we don't have the position correctly positioned for the changes that have occurred in the organization. And now you have this pool of candidates that applied for treasurer, and maybe we're gonna hire a controller.
Can it just be an email, like a quick?
Could be an email, or it could be a real quick form letter that you say, thank you for applying for the position of X. We've reevaluated our needs at this time, and we've decided that we're going to move in the direction of X. Please take a look at the new position. Here's the link. And if you'd like to be considered for that position, please let us know. That's what I would do.
Or we pull the position.
Or right, we've decided not to hire at this time. I think that's the courteous thing to do. Do you need to do it? But it certainly goes a long way in goodwill, because 2 years from now, your company's gonna have a job open again, and people are gonna remember, I never heard from them. They're kind of cranky, don't apply there.
Well, then there's only 2 degrees of separation in every.
That's right, yeah, there's no 6 here.
Nothing to add. I could talk about it all day, but we're not.
Yeah, we don't have time.
Yeah, we're gonna move.
Right. What time are we supposed to be done?
10:30.
Okay.
Even if I don't extend an offer, do I need to keep documentation? Yes.
Woohoo.
Look at that, easy. It is also on your sheet, your cheat sheet, that will discuss kind of how long, where, when. Failure to hire claims, you've already talked about it a little bit. I don't know if we need to go into more detail. Also, and I talked about this privately before when we were all eating our breakfast and drinking coffee, the Department of Labor and marijuana and unemployment, it's like a big mouthful of stuff, right? So do you need to keep documentation, right? If you are an employer who does anyone do drug testing in the room? Okay, well, this doesn't apply to anyone then. If you do drug testing, right, you're not allowed to do it for applicants until after you've made an offer. So you've made your offer of employment, then you're going to drug test. If someone tests positive for marijuana, right, and you decide not to hire them as a result, arguments have been made that this is potentially in violation of Maine's recreational marijuana statute, right? Department of Labor has taken the position that that employee, and I say employee, even though they never worked, but they had an offer letter, right? Potentially could be entitled to unemployment compensation, right? Because if they have quit their other job, now they don't have a job. And if they are entitled to it, they are going to come to you as a company. They're going to ask you to complete all the unemployment paperwork, right? It's not going to be charged against you. It's going to be charged against the pool. This is the way it's been described to me. Again, I haven't gone through this process with a client yet because it is also new, but keep in mind, if you are going to do drug testing, it has to follow the Department of Labor's drug testing policy. You have to have it approved by the state. Second, for all of your advertisements, you're going to want to make sure that it indicates the drug testing positive, not positive, getting through the screening process for any drug. The drug screening process is an element to employment, and in order to become an employee, you will have to pass the drug screening. How long do I need to keep the files? It's on your handout, and since we are running short on time, that's something that's super easy, and if you have questions, definitely reach out to either one of us to discuss more.
Oh, this is a whole workshop in itself, like this could be 7 or 8 hours, so we'll have to make it really quick. So performance management, a couple things. It's not in writing, doesn't exist. So the employee hasn't signed it, doesn't count. Everything has to be documented, everything has to be signed. Make it really, 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 really easy for your managers to document performance. Like, don't give them a blank piece of paper. That's not what they want. They want templates. So make it as easy as you possibly can. You don't have to turn performance evaluation into rocket science. The harder it is, the less likely managers will be to do it or do it consistently. So I am a fan of keeping things really, really simple. So have a performance evaluation form that managers complete prior to the evaluation. There should be no surprises. So in HR, we never, ever, ever want a surprise. We don't want to have an employee sitting in the chair at the performance evaluation meeting and say, oh my God, I didn't see that coming. That is not ever what we want to hear. So no surprises. So that evaluation should be a meaningful conversation. A look back, so a look back over the performance evaluation period that usually is a year. It could be 90 days, it could be 6 months. And then a look forward to include goals and objectives. I love a self-evaluation form, which can be the same form written in first person that an employee completes prior to that performance evaluation meeting. So manager and employee can make sure that they're on the same page relative to performance. And then you make sure that everything is documented and that employee has signed off on it. The employee has an opportunity to make comments. So whether they agree or disagree, still goes in the file. They still sign it, even though they may have 3 pages of disagreement. That's okay. Do you want to say anything about performance before we move on?
Yeah, in the performance evaluation form, I definitely want specific instances. I don't want it to say untimely completes projects. I want you to say like untimely completes projects. And then I want it to be colon, and I want there to be 2 bullet points or 3 or 7 bullet points, right? About each of the projects that you are using as an example. As to each statement, like difficulty interacting with coworkers, bullet point, oral warning regarding interactions with Sally, or sometimes needs to work on tone of email, C, email dated X, Y, and Z. To which you are going to get managers who are saying, is my job to do my job, or is it to keep track of all of my employees? It's both. It's definitely both. And the reason why I always push back on this is because it is so easy to document in this day and age, right? You have an oral warning, right? I go to Catherine, I say, Catherine, we need to talk about, Catherine's amazing. If I can't even off with like what we need to talk about. Jim, we need to talk about tone of voice and how you're coming across in emails, right? You are then taking your cellular device, which is literally on everyone at all times, right? And you are writing yourself an email and you are saying, such as March 22nd, this time and day, I spoke to Jim about tone of voice with regards to this email. I send that email to myself. I then have subfolders, right, that are private and locked down that no one else can find, and I drag it over so that when I get to time of year to perform this evaluation, I am clicking open that folder and I am seeing all the discussions where we've had. I also have in here all the amazing things where I have like reached out and said, great job. You did a really good job on this. Thanks so much for getting it out so quickly. Or the client was really excited about this. Thanks for your great work. And I'm sliding it over so that doing a performance evaluation form is not difficult by any means, right? Because you have this list of documents that you're just going back through and you're just bullet pointing. So that from a performance evaluation form is kind of what I have to say on that. Go through the other bullets real quick.
You shouldn't be having to rack your brain if you're a manager thinking of stuff. It should just be stuff that you're pulling from other information. It should be a copy and paste.
For performance improvement plans, right? I always wanted to have multiple timelines throughout the course of it. 30 days, 60 days, 6 months, 1 year. What I see in so many situations is we have long-term employees who have been with us for a decade who have had 5 or 6 performance improvement plans. And the reason they've had it is because there is like a 60-day review and the employee like gets it under control in those 60 days and then goes off the rails again, right? And then you have another performance improvement plan and you find yourself in the same exact position because they're unable to maintain it. Have it be a year-long process. Have there be multiple check-ins. And like what we mentioned earlier, nothing should be a surprise. It shouldn't be like, we've talked about this multiple times and now it's on your review. No, we talked about it last month. We talked about it 6 months ago when we did that other review. We talked about it 9 months ago. It's the same discussion. If we have this discussion one more time, unfortunately, we might have to terminate employment because this relationship doesn't seem to be working.
And the thing that helps to make that defensible is that if then you find yourself in a position where an employee discloses something relative to some medical condition or has a workers' comp injury, and you find yourself in a position where you have to terminate employment because of all of the performance documentation that you have, it won't look as though you set the person up because you've got the documentation that goes back a year. And the straw that breaks the camel's back is not the workers' comp claim. It's that the employee yet again did this same thing that they've been doing for a year. And I will tell you that we look at that at the commission. We look at patterns and we look at length of time.
And my favorite thing in the claim, you might say like, well, this person doesn't fall into any particular category. Like, I promise you, you have a lot of employees who on their second oral warning, right, the next day are going to come in and be like, you know that we're not disposing of any of this pursuant to EPA regulations, right? We are in violation of the law. And they're going to make themselves into a whistleblower, right? So after they have that first, second, maybe third oral warning, written warning, right? I want it documented because our timeline needs to show this person was having performance management issues before they made a complaint of a perceived violation of the law, and none of the action that we took against them had anything to do with their perceived violation of the law, had everything to do with who they are as a person and what their performance looked like. So that's one of the reasons why the documentation is so important, and even the oral warnings to make sure that you're writing it. Now, if you find yourself having forgotten to do this, you can make prospective, I don't want to say, see this is, I always hate having this sentence because it's always going to be taken in the wrong way, right? So listen very, very carefully to what I'm saying, right? We are creating documents that at the top of it has today's date. And then we are saying last week, I spoke to Sally about the tone of voice in emails, right? at this time in this location, but the document is dated with today's date. I am not creating a document that has last week's date on it that says what happened, right? Because I promise you the metadata in that document is going to tell me when you created that document. It's going to tell plaintiff's counsel when you created that document, right? So you can document things that have happened in the past, but make sure you are very clear that this is a past recollection as to what has occurred, right? Because I promise you a week later, you're going to remember it a heck of a lot better than you do 3 years later when we're litigating this case together.
So are you definitely recommending staying away from the paper and pencil documentation in this day and age? Like in our plant, our managers don't have access to cell phones or computers as.
I like paper and pencil.
Okay.
No, it's truly ease of use. It's truly ease of use that like if in a plant setting, but you know what I want in a plant setting? I want a piece of paper that says oral warning.
Right.
Right.
Okay, I want a piece of paper that says written warning, right? And I want
On a clipboard.
on a clipboard and a stack, I want 40 of them.
Yeah.
Right there, that the person writes on and they hand it to HR. Because the bigger problem is they write it, they leave it out. The last thing I want is another employee walking by and seeing like, ugh, don't got a written warning, read the whole thing because they left it on the desk. And you see that a lot more, right? It still needs to be secured in the same way. When that oral warning is occurring, you should provide them with the same amount of respect you would in any type of other warning. Bring the person to the side, say like, listen, not appropriate, we need to stop it. The only time in which an oral warning might not seem like an oral warning is, especially in a plant situation, right? Lunch break or other type of, I don't want to even call it social because it's not always social, but you've got a group of people who are standing around, there's a jovial nature, and someone makes an off-color joke, right? Whether or not it's about sex, whether or not it's about something with our political climate that touches on a protected class. If a manager is standing in that circle, I want that manager to say, cross the line, not appropriate for work, stop, right? And it needs to occur in front of everyone. And then afterwards, right, and not in front of everyone, but afterwards, that manager is going to go to that employee, ask to speak to them privately and say, I don't want to call you out in front of everyone, but you do know that's in violation of our EEO policy. It's in violation of our harassment policy. It may have seemed as though it was jovial and appropriate, but just remember that it's not, right? Immediate action, because I don't want that manager standing there and just being like, holy cow, that just happened, but not shutting it down at that moment. And then like later that day, potentially going to them because none of the other employees see this private discussion that's happening. Those other employees are going to think it's okay. And I hate using any legal terms that it's become a hostile environment and they don't feel comfortable because that manager is not protecting everyone's rights. So that is the only time that a call out or an oral warning, right, is going to be appropriate to conduct in front of other peers, is to shut down something like that. And then you're doing a very personal follow-up and having a discussion with that employee and making sure that they comprehend why what was happening was inappropriate. And I don't mean to pick on manufacturing settings, but that's where I see it most often. Or in a professional setting at lunches is oftentimes that it gets starts getting a little bit inappropriate, and then bam, someone crosses the line. If a manager had cut it off 3 steps before, we wouldn't be having this kind of awkward moment where you're re-steering the conversation to something that's completely.
Get your managers and your managers, get them thinking in the realm of being a role model for all employees in the organization, but that they're role models and their behavior is viewed by other employees as being okay. So if they're talking like pirates in the break room, then everybody ought to be able to do that. So I think the more we impress on managers that they speak on behalf of the organization and they're looked at as role models because they are role models, that kind of hits home a little bit with them. Yeah.
I wonder if the manager's the culprit in fueling the fire for, certain abusive culture in a
We're gonna get to
organization.
that.
Okay.
So, well, my first question would be, have you done your training? And the second question would be, if you have done your training and your manager's still the culprit, he or she has probably already fired themselves.
Right.
That's my opinion. I have a zero tolerance.
Right.
Okay, so we're gonna move quickly through this. Emails between manager, employee, time off requests. If people are doing it by text message, I want a screenshot of that text message, send it to HR. My recommendation is I don't believe in communications by text message between managers and employees. I understand that that is very much a culture decision. If your culture is one in which that is how time off requests or being late or anything like that is communicated, manager training, that they are screenshotting it and sending it to HR so that we have documentation as to when a person is late, leaves early, all of that stuff so that we are keeping appropriate records. I'm gonna let you.
Best practice documentation. So if you are an organization that uses computers, you are required to provide annual training. People kind of freak out when I say annual because it's not just upon hire, it's annual. So then 30 days of hire and then annually to provide ergonomics training. The Department of Labor in Maine does a really nice job of producing a worksheet that you can use in the training so that you make sure that people are comfortable at their workstation. If you get some no's as you do the worksheet with an individual, then I would strongly encourage you to bring somebody in who can do an ergonomic assessment. Workers' comp, if you have Mimic, they're awesome, and they'll do it at no charge. You don't have to pay a physical therapist. They'll come in and they'll do a workstation assessment, and they'll help get the person set up so that they're comfortable and it's in their best interest because fewer workers' comp claims. But the law requires it. In Maine, you also have to get out an annual memo. Did you want to say anything about that? Okay. Rest break waiver form. We could talk a lot about rest breaks, but Maine, if you have an employee who is scheduled to work six hours or more, you're required to offer them a break during that 6 hours, which is typically a rest break. You can, but you don't have to, you can allow employees to waive their right. Typically, this is an unpaid meal break. They can waive their right to a break if you allow it. I will say that some organizations, particularly retail, really doesn't want to allow employees to waive their right to a break because they staff around those breaks, and it adds payroll dollars if people are working through their break and getting paid for it instead. It also put you in an overtime situation. So if this is only for non-exempt employees, so if you're an organization that would allow employees to waive their right to a break, then you have to do that with a rest break waiver form.
Rest break doesn't apply to exempt.
No, the labor laws by and large don't apply to exempt employees.
You know if Massachusetts has the waiver?
I can tell you, I just did a handbook for a Massachusetts employer. So there's on your thing, my email address.
Yeah.
If you send me an email, I'll send you that I'll send you that policy. Yeah. Employee policy manual receipt. Hopefully you all have handbooks. I would always recommend that no matter how good the person is who's writing your handbook, and I think I'm pretty good at it, I always recommend that counsel do the final review. I don't really like to have lawyers write handbooks because they're all lawyery. They're not really very inviting. But I do recommend highly that counsel do the final review because they're going to see things that you all have forgotten, or they're going to say, what about if, what about this, what about that? they're gonna wanna make sure that you've included certain things in your handbook that are really easy to overlook.
I actually will never write a handbook from scratch.
Oh,
I
good.
ask the employer to provide me with a full outline of their culture, which usually starts with an opening paragraph. And then I have a checklist that I want them to provide me with. Tell me about this, tell me about this, tell me about this. They provide me with that information, and then I turn it into maybe a handbook. Like, we can call it a handbook. They've really done the heavy lifting, and then I put it all together. But I tell you what, my brewery clients have very different handbooks than my big clients do. And if I was going to have, if someone came to me and thought that like me creating a handbook was going to be a $500 deal because I was just going to hand them the same thing I handed to the last client, they're not getting anything from me. That doesn't provide any value to them. So signed and dated, you need to have language in there saying it's going to change and update at the employer's discretion, right? And that they might not be provided with a copy. If you have an intranet, I want it available to your employees and exactly like where it's going to be located. I also like to have that posted somewhere, right? Say employee manual is available at X, Y, and Z. I'd also like to have it 3-hole punched in a 3-ring binder in the break room or wherever else you have all your labor posters. I never want to be in a situation where your managers don't know where the handbook is, your employees don't even know you have one. I want it to be out there in front. I want employees to be able to access it at their leisure whenever they want to. Remember that this document, similar to your job description, is a living document. If you tell me you haven't looked at your policy handbook for the last 3 years, but don't worry, we're good, I promise you, you're not good, right? This is looked at annually. Oftentimes, it should be referred to at least monthly by people who are in your HR department, because I promise you, if you get on the phone with me, within the first 10 minutes of our conversation, when you're describing what the problem is, I likely am going to say, what does a handbook say? Yeah. Right? Well, this is what my recommendation is. What does your handbook say? Right? Because your handbook could say something quite different than I'm going to say. Okay, unfortunately, the action we're going to take right now is this. Now we're going to update the policy so that next time this happens, it doesn't look like that. And that's what happens if you haven't had it reviewed by counsel before you're attempting to institute it. So some clients, and I know that this is, it's rare, but we've done this presentation before. I think I'll say if you don't want a handbook, don't have a handbook, right? But I want at least 4 different policies. One is an EEO policy, one's a whistleblower policy, one's an anti-harassment policy, and then you have the full sexual harassment, anti-sexual harassment policy that's required by law, right? At a minimum, that's what I want set forth. You have a bunch of, you still have a bunch of risk by not having the rest of the handbook, but if your organization is such that a handbook just isn't going to work, you at least need to maintain those 4 very basic policies in order to survive without, and I don't even want to say without risk, in order to be a good employer no matter what, right? Which I know everyone's attempt is to be a good employer. You need to at least have those basic foundational policies.
The other thing that I recommend is that when you have your onboarding, your new employee orientation program, that you pay your non-exempt employees. You give them time to read the handbook that's on the clock. I don't care what you do with non-exempt. You could send them home, give them a link, let them read it on their own. But with non-exempt employees, if we can pay them, then we have no reason whatsoever for them to say that they aren't aware of what's going on in the policy manual, or, gosh, I'm not going to take that home and read it. I'm off the clock. I don't think about work when I'm not at home. So I also include that in my policy manual receipts for non-exempt employees that I've been given time to read it.
If you rehaul the handbook, should they assign a new receipt?
Yeah. And another thing that that we talk about is during that performance evaluation meeting is a really good time, even if you haven't overhauled the handbook, but to bring it up and talk to that employee about, so, any questions about anything in the handbook or anything that you want to talk about, and just have them initial that you've had that discussion again in the time that you're not doing a complete overhaul. it's a good time for stuff to come up that might not come up otherwise.
So you're going to provide your sexual harassment policy to all of your employees yearly. So every year they're going to get it, and they're also going to sign a receipt of it that is signed and dated. And then for your managers, you're also within 6 months of them taking on a management role, you're going to provide additional training as to sexual harassment, how to identify it, what to do if it's brought to their attention. And you're also going to have them sign a training receipt with regards to that training. And oftentimes that gets overlooked, that's 6 months. But it might be that they've been employed for 4 years. Okay, now they're changed title to a manager. Within 6 months, I want another training as to sexual harassment because their duties and responsibilities have now changed.
The guidelines that the EEOC puts out for prevention of harassment training are to be considered minimal. Like they expect you to go over and above what they require. So a good rule of thumb is to at least do that manager training. I like to see clients do it annually. I don't think that the value of that training can be overstated.
Property and equipment receipt, this is really once we get to a termination discussion to make sure that you have maintained everything. Training documentation, again, that is from an EEOC, Maine Human Rights Commission. We want to focus on, especially with our managers, information that they've had training on our policies and procedures, all kinds of that stuff. Go to the next slide. Termination documentation. Employment termination checklist is hugely important because we want all terminations. They're never going to look the same, but as well as we can make sure that we are following a similar structure, the easier it's going to be. And honestly, the less emotion that's going to be involved in it, which is important because oftentimes when we see claims, it's based in large part on that last interaction and how the employee felt when they were leaving the employment of the employer.
I do have to share a quick story with you because allowing somebody to leave your organization with dignity, as Tani alluded to, is absolutely key. I had to terminate somebody's employment about 20 years ago because he was a data center key punch operator, data entry operator, and was using his work computer to go to pornographic websites. And our IT found out, brought it to HR. The investigation occurred, and we decided that his employment would be terminated. Came into my office, and the manager initially had wanted to make an example of him because he was in a data entry with 30 other or so employees. And I said, nah, I don't think we're going to do that. I think what we're going to do is this. So we had the meeting with him, and he was embarrassed and remorseful, and wondered how we were going to allow him to leave and whether or not we would tell his mother, because his mother was a vendor with the organization. Make a long story short, we allowed him to get his things. We put everybody on break, allowed him to get his things, allowed him to leave out the back door, and allowed him to leave with his dignity, and never heard another word from him. So, and there was a lot that happened that I don't have time to go into. I would highly encourage you to, regardless of whatever the circumstances are, is to allow somebody to leave the organization with dignity. They are far less likely to sue you when they're allowed to do that.
Your employment termination memo, you're having whoever was involved in the termination just write a memo to file. I terminated so-and-so today. The discussion lasted about 20 minutes. These were the people who were in attendance. The reasons given were set forth by so-and-so. Response as to this, no response. The employee was notified COBRA information would be sent on this date. They requested their personnel file. They didn't request all of those things. Access to computer was shut off. The employee has requested access to X, Y, and Z personal files. Follow up within 3 days with IT, send through. However you're going to do it, make the memo to the file, because otherwise, no matter what, the perception of that meeting is very different, right? There's how the employee is perceiving it, how management's perceiving it, and then there's somewhere in the middle. There's always like kind of what the truth is. By memoing it to file right after it's happened, it's going to be easier if we ever get into hot water later on.
And you do want to keep that memo very clinical. So, no emotions, no opinions, yeah.
I had an interesting call from a client a few weeks back that had terminated an employee about 6 weeks ago, and somehow they never communicated it to the payroll company. So therefore, the person was still getting paid.
Yeah.
So that checklist becomes really important.
Yeah, no, you think? So what is, do they have a right to recoup those funds?
You can ask for it.
Yeah, it's gonna probably be it would probably be a small claim. I mean, they can request it, they can seek it, no work was being performed, but,
They can't seize the bank account.
yeah, so it's
really?
gonna be a small claim. It's gonna be either we overpaid you, this is what it is, you're gonna set it forth on any unemployment paperwork saying in error, they were paid this amount through this stage, right? Yeah, unfortunately, that it goes to the importance of having that checklist, so,
Cost of doing business,
Yeah,
cost of a mistake.
interesting.
we're gonna kind of rush through the rest of it. Severance agreement, you're gonna talk to counsel about, because do not just keep using the same severance
Oh my
agreement,
gosh,
because
please don't.
I promise you, you're just creating more liability for yourself. Documentation related to the termination decision. Before we even get here, I want to make sure that you know exactly why they're being terminated, and if it's for a policy reason, I want you to have identified it, and I want documentation showing all of it without there being questions, especially if this is someone who has had taken FMLA leave or you've accommodated a disability. So many times I get these attendance spreadsheets from an FMLA standpoint, and I'm like, wait a second, there's like questionable dates here where we're not sure if they showed up or didn't show up, and you're terminating, even though we don't have a clear picture of what their attendance looked like. We don't want to be in that situation after the terminations occurred. Get your ducks in a row before we have the conversation. I'm gonna do the next one. If it's not in writing, it doesn't exist. That really becomes the most important. We've talked a lot very generally about these things. Payroll forms, let everyone know who's involved, all your vendors, that this person's no longer employed. You don't have to go into details, but there might be some vendors who you need to contact and be like, so-and-so is no longer with the organization and doesn't have authorization to sign on behalf of the company. In some situations, we do have to communicate that, again, with dignity, without providing any information as to why. And you might have vendors who are like, hey, what's the story? We're not at liberty to discuss it. Just know that they don't have authority to sign on our behalf anymore.
So documents you need. So we kind of put this together based on a lot of different potential audiences. So whether it's the Maine Human Rights Commission or OSHA or anybody else, these are documents that you need as a business owner to make sure that that you're in compliance. So an employee handbook, department policies, safety manual, OSHA logs, safety policies. I mean, you can read these yourself. We don't necessarily need to go through those. Organizational chart, a lot of organizations don't really have one. I think it's really important for employees to know where they fit into the organization, and whether you say organization hierarchy, chain of command, whatever your terminology is, people like to know where they fit. And having that picture lets them know who's the boss, who's the boss's boss. If there ever is an internal complaint, then they can't ever be in a position to say, well, gosh, my boss is the one who is the perpetrator, but I didn't know who her boss was. So I kind of was at a standstill. So let people know where they fit.
And related to that, in that job description that we keep talking about, say who it reports
Yeah,
to, so they at least have the initial point of contact, but as set forth, having the organizational chart will allow them to understand who reports to who. Let's go to the next one. You need manager support. This goes back to our manager training discussion. We think everyone who has an HR function is great and amazing, but they are only as good as the managers who are overseeing the employees. So without properly trained managers, you're unable to fully function and do the job that you need to do. The consequences, and this is the way I always present it to managers, and we both perform manager training. I mean, I did one for 5 hours last week, and it was empowering them to understand where their job ends. Right? If someone says, I need an accommodation, that discussion doesn't go further. You go to HR. If you see inappropriate sexual language being used, right, you are stepping forward immediately and you're not running to HR. Like, what is your job and how does your action bind the organization? Oftentimes managers don't recognize that their knowledge is imputed to all the other managers in the organization. So they might have knowledge and then an employee might come and be like, Tani, I have to tell you something, but you can't tell anyone, right? That's the managers are like, she told me I couldn't tell anyone. I don't care what she told you.
Yeah.
You come into HR and you're saying that. And as soon as the employee says that, your response is, I recognize that you don't want me to share this, but this is not the culture that we want to be preparing, and I need to share this with HR. So I appreciate you telling me this. I'm happy that you trust me with this information, but we need to take further steps because this is not okay. So you get in that employee's corner, but you share it because the knowledge I now have is imputed to all the other managers in the organization. And if everyone's working in a silo and not sharing that information, you're just expounding the risk that is available to the company.
What if somebody goes to the manager and says, I don't want you to tell anybody, and the manager says, I don't want you to tell me?
So you're creating a culture in which you don't have you don't have an open door policy, right? What you can say though is, I need to tell you something, and if you say, if it's something that you don't want me to share, you need to recognize that depending on what you're about to share with me, I may need to tell HR or another manager, right? I won't know the answer to that question until you tell me what you need to tell me. So I would recommend you sharing it with me, right? And then, but I cannot promise you that I'm not going to share it.
And please trust me that I'll do the right thing with the information once you've shared it.
Yeah. So you might not want it. I promise you, I've gotten information I don't want, right? But I then need to take all the time away from my day job and make sure that the rest of the organization is aware of what's going on.
You recommend the manager tell the person before they tell them?
Yeah. Oh,
yeah.
I
There's
do.
no such thing in the same way that we do in our handbook, saying like, we are going to attempt to keep your report as confidential as possible, but recognize that in the course of an investigation, the whole purpose of an investigation is to get more detail, and the only way to do that is to potentially share certain details. So in that same sense is how we're going to respond. And yeah, unemployment discrimination, wage and hour, all those things, the managers are binding the rest of the organization. Okay, this is stuff I think we can you guys can read on your own time. But it's those foundational issues that you need to do in order to, we've touched on a lot of them. Yeah. Also recognize, we've been saying put everything in writing, right? Which I'm sure you're thinking to yourself, my lawyer says not to put some stuff in writing. You're right. As soon as you have knowledge of a potential claim, right, I'd rather you call me. And then I want to be involved in communications. But once you call me, I never want to see an email during discovery that says, I talked to the attorney and the attorney said, bam, right? And I'm not CC'd on that, or I'm not otherwise providing that email. If you send that email to all your managers, any attorney-client privilege we've created, right, has just been lost. Absolutely. Okay? So now I have this document that if we're in a lawsuit, I'm going to have to produce that is me saying, I identified that we had risk here, and I advised the client of X, but they did Y. Right. It looks horrible. There are very few ways for me to like work around that issue. So recognize that there are some things you're not going to want to put in writing, and what it's going to be definitely, you guys are all good business people, you have good instincts. You're going to know when your instinct says, this is not something I think I want in writing, I think I need to call an attorney.
Walk down the hall, pick up the phone, have a chat. Last slide is possible templates. So we talked a little bit about making things really, really easy for your managers and supervisors. If you develop some templates that make it easy for them to have that clipboard, have a verbal warning form right on there. They fill in the blanks, written warning, self-eval, have all of this stuff that makes it easy for managers to do that part of their job, which HR is really good at, but managers are really HR business partners. They're mini HR people, and we need to train them so that they're successful in their jobs. And by providing them with this kind of information that we can help them with, makes them do their jobs better. Okay, all right, I think that
That's
was a
it.
lot.
Yeah.
Thank you.
Thank you, guys. Thank you.
Thank you both very much. And I do have an evaluation form, if you wouldn't mind filling that out, I can get those to you.
And if people want to email for that, like pick a adventure from an independent contractor standpoint, my email address is on that first slide. So just email me at talvarez@veraldana.com and I can send you the PDF that you can use to make that determination.
And if you think I might have something that you want, just let me know.
And thank you very much. Thank you, Bill, for sponsoring us. Thank you. And thank you both for speaking, and thank you for hustling. See you next week.
Yeah, and I mean, one of the things to take away from that is like, bring your managers next week.
Yeah,
Like
right.
your managers are going to bind your organization. So when Catherine says, bring all your people, bring all your people. I don't know what the Doritos reference is because I hadn't heard that.
They say
now.
munch all you want.
Okay.
We'll make more.
Yeah.
Yeah. Oh, and I want a quick, can I have a quick picture of